Yeah, all right, already. Representative Pearson, you're recognized.
Thank you so much, Chairman. And just want to just get this clarity, sponsor. If someone in the public believes that their constitutional rights have been violated by a rule of the Tennessee House or Senate, the only redress that they would get would be going, in essence, to federal court and explaining that their constitutional rights have been violated. Is that right?
Representative Bulso, you're recognized.
Thank you, Mr. Chairman. In part, that's correct. But as I mentioned a moment ago, by going to federal court, you also have access to the Supreme Court of Tennessee.
Yep. Thank you.
Representative Pearson,
Thank you so much.
Follow up.
Thank you so much, sponsor. Sponsor and chairman. Look, I think this is not only unconstitutional, but it very much is anti-constitutional. And the threads that were mentioned before about being ripped apart is happening with legislation like this, colleagues. Look, the founders created these co-equal branches of government, right, with the idea that one would not be usurping the other. And after 228 years of this state surviving in this way, we now have legislation that is trying to make the Tennessee legislature and the rules that it makes and the actions that it takes to not have the right of judicial review in the state of Tennessee. We serve Tennesseans, and we deserve to have access to every court that is within Tennessee. There were the cases that came up before, sponsor, with Miriam and Allison and Erica, where parents were dragged out of a hearing room due to having signs like those right there. We will not be silenced, things like this. And because of that, they went to court, and that judge said this after our Attorney General's team said, "This threatens to upset the delicate demarcation of powers," said Cody Brandon, an assistant Attorney General who was representing Cameron Sexton and technically, I guess, us. And the judge responded, "But that's not a power without check." I actually got the Attorney General, two of them actually wrote opinions about this matter that should help guide us in this, because this is quite dangerous, what you are recommending we do. But to Mayhe v. Wilder, the Tennessee Court of Appeals has opined that generally under Article 2, Section 12, each chamber has a right to make its own rules and is the sole judge of its rules, but cautioned that even that broad power of the legislature is always limited by the Constitution of the state and of the United States. That's Mayhe v. Wilder, Tennessee Court in 2001. It said, explaining that the legislature, like the other two branches of the government, derives its power and authority from the Constitution and must therefore subordinate itself to the requirements of the Constitution. This is not about political questions, which if you were mentioning, I would understand whether something was justiciable or not, if it was a political question, which they argued in Mayhew as it related to the House rules. It was non-justiciable because it was related to something that was an enumerated power within the Tennessee State Constitution. But what you are recommending, from what I am understanding, is that all rules related to our House procedures, all the things that we are doing, whether that be discriminating against members, would be resolved by the Tennessee General Assembly, which is very problematic because in Mayhew it also says this, that although Article 2, Section 12 authorizes the legislature to make its own rules, it's related to textually demonstrable constitutional commitments, things that have been enumerated in our Constitution. They go further in reviewing the challenge that was brought before, and they say the legislature has unlimited power to act in its own sphere. They do say that. But its actions are always restrained by the Constitution of the state and of the United States. That's the Bank of Commerce and Trust v. Center. The two attorney generals that I mentioned, this is what they said. They said the power of the legislature is restrained by the Constitution of the state and of the United States. That's Paul Sumner's. And he says the power of the legislature is not totally unlimited, which this legislation seeks to make it. It must be exercised in accordance with the protections and the rights guaranteed under the Tennessee and United States Constitutions. That's Attorney General Slattery. I cannot believe, Slattery, thank you. I cannot believe that we are actually arguing about whether or not we are going to make it so that our legislature would not be able to have judicial review, that our rules, which we know oftentimes can be problematic, which we know can abridge the rights of people, we would not be allowing the public. We would not be allowing the public to go to court to ensure that their rights are being retained. I can understand, as a legislator, and we're all legislators up here, I can understand you saying, House rules and House members, there might be something different. But you're saying the public can be mistreated, rules can be passed that limit their rights, and that Tennessee courts would not be able to say anything about it. That is not just unconstitutional, it's anti-constitutional, and it removes the ideals and the ideas of this republic.
We
May I respond, Mr.
have
Chairman?
sponsor. We have a lineup